All right, welcome back, everyone. We're back on the record. You can remain seated. Mr. Thierman,
Yes, Your Honor.
I'd like you to proceed, comment on what you just heard from the special master, argue to the court how that plays into the relief requested by the petitioners and justifies the court ordering the extraordinary relief of a writ of mandate. And let me focus you on a couple issues among whatever else you want the court to know. What I took away from that is an extraordinary situation, some discretionary judgment calls on the best way to approach it, quite a bit of fraud in the system, guidance from Department of Labor. I mean, how does that all translate into an abject abuse of discretion sufficient to justify this court utilizing the extraordinary power of a writ of mandate to direct another branch of government how to do its job? Go ahead.
First of all, although I'm not going to, I'll come back to the report, but you asked a specific question, and the answer is it comes right out of the Department of Labor's reaffirmation that due process requires payment until a hearing for those who have been approved, who have a letter of eligibility determination approving them, who have been starting to receive payments, and then they were stopped unilaterally. And that is probably at least 40% of the class. And the UI P.U.A. cycle whirlpool going down, as I understand it, is easily resolved by the rule is you have to exhaust your UI. Now, these people who have complained about the UI have letters of determination from UI saying they're not eligible. They hand it to D.E.T.R, and the D.E.T.R says, well, you're in the UI system, so we won't pay you P.U.A. Which is it? And the answer is, well, you exhaust your UI, because one of the criteria for P.U.A. criteria is exhaustion of UI. So you start getting paid from one system, and then you get paid to the other. And not that you just fall into this void, and you have to start reapplying. But let me go back logically and see if we can reaffirm or distill what we have here. Mr. Ganasso did a great job, a heroic job, concluding that D.E.T.R has not done its job and given reasons why. And frankly, I can disagree with the fraud thing all I want. I mean, $10 million out of the state of Washington's $2 billion. That sounds headline $10 million, but it's not really percentage-wise.
Actually, it was in excess. It was more like 17 million, but okay.
Even 20 million. I mean, there is this inherent system of fraud in this. There's inherent fraud. And yes, the system was not designed. I mean, we can criticize the C.A.R.E.S Act. I mean, maybe we should have done it the way the part one of the C.A.R.E.S Act does it, where we pay people a bounty, which is what banks get, for approving loans, instead of having people who are not incentivized to approve it or give out the money, but disincentivized, administer it. But it's what we have to work with. This is the statute. This is what it says. This is the way it's being done.
Well, let me make a comment there, because I want to make sure, it's not this court's job to be political in any way, but I think everyone on this call can agree we should be thankful we're in a position that we are, where Nevada has been the beneficiary of funds from the federal government to give out to Nevadans in need that otherwise qualify. So no one here is criticizing the act. What the court's being asked to do is make a determination that D.E.T.R, despite all the challenges it faces, has failed. I'm going to go through what the law actually requires in more detail, but that's what I'm being asked to do.
All right. Now, while we have these secret ex parte, which I was not part of, explanations of the fraud, all I can take away from it is you have VPN addresses or IP addresses that would be easily explained by VPN, non-specific, apply to people who've already applied and gotten their approvals retroactively, which is exactly what the Department of Labor and JAVA says you can't do. And I did submit a DOL memo which I don't think anybody could argue with, as the court could take judicial notice of it. Back in 1975 or so, when Java came out, and on page 12 of that memo, it's very specific about redeterminations and why those redeterminations do not suspend the obligation of paying money that has already been approved. And it also goes on, it says specifically, when a claimant was initially found eligible. In that category of initially found eligible, I would put three kinds of claimants, three groups. First, people who have gotten eligibility determinations, not to be confused with monetary determinations, but eligibility determinations saying that they're eligible. They have been found eligible. And saying that black is not black when black is black doesn't help. That's what the words say in the letter. That's D.E.T.R's position, and they are eligible. The second point, the second group of people who already started getting payments. They would not get payments otherwise if they were not eligible. If they are eligible to get payments, they have been found eligible, and those payments should be continued. And the third group is when you say a P.U.A. claim is impacted because of the existence of a U.I. claim. Now, one, if you have to exhaust U.I., we'll pay from U.I. first and then switch over to P.U.A. Two, it's got to be one program or the other. I've made this point over and over again. And three, it doesn't affect the F.P.U.C. And for that, I will turn around into the fact that you don't pay on number 3 on that DOL memo. It says payment of benefits for weeks not in dispute. Well, I would say it's payment of benefits for a program not in dispute. Somewhere along the line, FPUC attaches, whether it attaches to UI or it attaches to PUA, and those benefits are not in dispute. It's the underlying program, the trigger mechanism that's in dispute, but we know it's one or the other. The other thing that I would point out to is this fraud has been around forever. And point number 4 says on that same page, when the question relates to eligibility or possible fraud for past weeks only, benefits claimed for current weeks may not be suspended while the investigation is current. So if there is a 1 out of 12 self-certifications or 12 looking for work weekly certifications, that the UI that comes from an IP address outside the country or outside the state, fine, suspend that week, maybe, or even don't suspend that week. But don't go back and say, oh, well, this is fraud, we stop, we don't pay anything. Now, the other thing is this, and again, I do believe in due process, but due process means process that is relatively quick. For whatever reason, this program is 18 weeks without paying people, whether it's because the site didn't go up on time or because they've been not paying even as a result of the site going up. And now they're introducing an appeals process that says on its face, it's not going to begin until sometime in late August when they get a calendar ready. So we're talking about September and October, and we're going to have how many claimants a day? 20, 30, 50? We have 130,000 plus claimants. And if I add the numbers up on page 119, by the way, the first 4 categories only cover 50,000 claimants, not 139,000. And if I add the other numbers in, I'm guessing it's under 75,000. So we have 75 identifiable issues of fraud, some of them overlapping, and we're still holding up 139,000 payments. And again, holding the group hostage for the ills or the bad few is not what due process is about. Now, there is a lot of issues about timeliness of processing. Okay, the people who are in limbo, who have never received a denial and never received an approval, they're just sitting there. And D.E.T.R says, well, the normal stuff is it's too far, we can't do it. Okay, well, what's normal? What is when due mean? The DOL letter I sent you says 3 weeks, 3 weeks from application. The Jenkins case says you don't look at the date of determination as the starting date for when it's due, or what's administratively feasible, or administratively as feasible or fast as possible. You look at the application date, because otherwise we're simply measuring how long it takes for the state's treasurer or state controller to write checks once a decision has been made. It is looking at it from the point of view of the claimant, who has lost his job through no fault of his own or her own, and ought to be reimbursed or paid as normally as possible. And for those weeks where, like Mr. Dinesh maybe has 1 week where he earned too much, okay, just that he doesn't qualify for that week. And I should say, by the way, in that same memo, DOL distinguishes between forward-looking things and past-looking things. I don't know what percentage of time D.E.T.R is spending looking at old stuff, but once they make a determination, then they should move on. Instead, we have determinations, redeterminations, redeterminations. We never get past point one. The purpose of this whole exercise is providing immediate relief. And when you make an omelet, you break a few eggs. There's fraud. Not to be condoned. It's not to be, applauded. But these kinds of scare tactics, McCarthyism, I call it, of fraud in the air, not explained, can't tell you, can't tell me what it is, not specific to a particular claimant, is no reason why the system should be breaking down and not paying. Now, it looks like to me that there are people who have been deemed eligible by the three methods. One, they have a UI claim that's blocking. Two, they have an eligibility determination favorable. Or three, they've gotten payment. That payments are without notice, without any reason, interrupted, or never made. That's a denial of due process right there. So if you put an order out that says they have to be paid, at least going forward until they have a due process hearing, then that will relieve a lot of pressure. If you put a notice forward that says they have to be paid FPUC, if they are eligible for UI and or P.U.A, because the only reason given for blocking, and it says, we have determined you're eligible for UI. That's what the letter says. Okay, you've determined it. Now give them to FPUC immediately. And if there's only $1 for them to get in the UI claim, then I assume after they exhausted that dollar, then they are eligible for PUAC. So then start paying them. Instead of, we have this paralyzing, it goes into nowhere. And I am not going to say that D.E.T.R isn't understaffed, or that people in D.E.T.R aren't trying the best they can. Although I will say, whether it's their subcontractor or them that does it, it doesn't matter. They pick the subcontractor. And if they have the money to buy a subcontractor, maybe they had the money to hire another state's agency that does it right. Maybe we should offload this onto Maryland or Pennsylvania or some other state agency that seems to be able to process quicker, because that's one of the options that are available to the state. I mean, but to the people of the state of Nevada, D.E.T.R's paying 55 or less percent of the claims. And I can't believe 50%, 139,000 people all got together on the same day and decided to commit gross fraud, all of them together in the same way. It's just not conceivable. And the problem is, when the dust settles down and we go through all these hearings, at least for the people who are starting to receive benefits or have been deemed eligible for benefits, they'll have been starved out of existence. They'll either have been on welfare and have lost contact. I mean, one of the things is the two-party identification. Did anyone think that the reason that their phones are turned off or don't respond is because they've been turned off because people can't pay their bills? I mean, some of the answers to these claims of fraud are just so obvious and so heartless that no one just asked. I mean, to a certain extent, there's some kind of, I don't know, disconnect. Maybe, yeah, it's funny too, because I was thinking about one of the common economic theories behind why we have disparity between the black economic community and white economic community goes back to the redlining or red districting of housing loans in the 50s. And when people retired or people got out of the service in World War II, if they lived in a white neighborhood, they were given housing loans. And if they lived in a black neighborhood, they weren't. And the house is the biggest investment most Americans made or make, and that produced wealth. Whereas the black neighborhoods, and you can look at a map and look at Baltimore. My son, I told you, is an ER doc, he's in Baltimore. I mean, they have one of the worst ghetto problems, and those same lines of where the problems are match exactly to where the redlining was done in the 50s and where people couldn't get loans. Well, who are the gig workers? They're immigrants, which may, by the way, account for some of the offshore VPNs, because if you really want to watch Ukrainian television, you can't do it from the United States. You need an IP address in Ukraine, or they're people who are high tech and have security for their clients, which also allows for a VPN. But in terms of they're minorities. I mean, the people who are in this group are minorities because they're immigrants or legally working in the United States. They file tax returns, or they're minorities because and they produce, state business licenses. They produce Lyft daily reports or weekly reports that they're working in this state. And now they have a VPN address that comes from out of state, and all of a sudden you say, oh, you can't be, I got an issue of fraud here. If you have started paying them, pay them. If you have an issue of fraud, indict them. Yeah, maybe it's unreasonable to expect that you're going to clear out the other 50 or 100,000 claimants in 3 weeks. But now it's 18 weeks, and it looks like we're going to go on to 30 or 40 weeks, and these people are not going to get paid. And it defeats the purpose and it perpetuates the economic disparity between this group and the people who have normal corporate jobs. People who get W-2'd either by the government or big corporations aren't suffering this kind of pain. And if we weren't going to cover these people to begin with, there wouldn't be a P.U.A. So obviously the system, as broken as it is, was designed to help these people, and instead the very things that don't match, that don't fit into the UI system, is causing all these problems, and they're not getting paid. So the disparity between this economic group and people who work for corporations and people who work for big business, or who are wealthy and self-employed, because if you're wealthy and self-employed, if you're a doctor or lawyer, you incorporate, you do a Chapter S, and then you pay yourself a W-2 for tax reasons. But these people don't, and there's no reason that they have to. What I'm saying is that this situation there's a problem. I don't even care how it got here. And Mr. Gonzo did a great job of explaining how it got here, but his solutions, we don't have time for. If he had proposed this 3 months ago, great. What we have time for is writing a check for those people who have been predetermined to be eligible and following the due process, even if it costs us, even if there are people in there who are going to get away with something. It's minuscule compared to the harm that's going to be done by not paying them. And percentage-wise, it's well within the 10% of the program's expected loss. And if Nevada has a problem because it has more gig workers, because it has more entertainers, people like entertainers typically are self-employed, or it has more Lyft drivers because the vibrant transportation services that go on in Las Vegas, or it has more of any of these people than any other state, I'm empathetic. But that doesn't mean we can't do something about it. It doesn't mean we can't service them. It doesn't mean that D.E.T.R has done its duty or not done its duty to pay when due. And when due can't be 4 months, 5 months, 6 months after an application. 3 weeks, okay, stretch it to 6. I mean, we already used up 10 weeks getting the site online. But even stretching from there, when are these people going to get paid? And that's what this lawsuit is about. It is about paying these people. It's not about fixing D.E.T.R. I mean, yes, it would be nice if D.E.T.R were fixed, but it's about paying people who are deserving of being paid. Let me just, the numbers don't add up too. I mean, we keep shifting this fraud thing. All right, now I told you page 119, that doesn't equal 139 applicants that are not been paid. Oh, that's what I was thinking. The reason why more Nevada, the checks are higher for Nevada is because we delay more so that the bank pays more. And the catch-22 on the banks, it's the banks have a $10,000 or whatever limit or whatever the number is, and that comes originally from D.E.T.R on these payments saying, uh-oh, this is too big for unemployment. Nobody gets a check that big for unemployment. So D.E.T.R has created this mess. The identity fraud, which I suggested to the special master, fine. That comes out of the card. You're giving people cash. Don't give them a card. Give them a check. Let them go to the bank. Let them provide 2 forms of ID before they cash it. Let the bank do the identity check. Why are we doing an identity check when we're going to issue? Well, if you issue a check from the state of Nevada that these people can take to a bank, and then, by the way, if there is fraud, if that person doesn't exist, or if that person assumes someone else's identity, fraud is on the bank. Fraud is on the bank. That's the way the UCC works. It's not on the maker of the check. If the check is presented and it's a fraudulent signature, the fraud is on the person who cashes it. Now, I don't know what bank the state of Nevada uses, but that bank should earn its money and check for 2 pieces of ID. If you want a direct deposit, that's fine too, because it's the same thing. But issuing these pay cards is an invitation for fraud. It's cash. The idea is you offload as many of these security checks as possible and rely on the private sector to do it. And that putting those checks in the hands of people instead of putting cash or these cards in the hands of people would be one way to do it. Another way to do it is fine. You've already determined eligibility by these 3 methods. Why is there not payment being made? Why is it that these 30 some odd adjudicators, none of them have a button on their desk that says pay? And none of the adjudicators, as far as I know, can you call up and say, hey, I'm on the screen, I'm looking at my thing, can you pull up my screen and let's go through this together and we can work through this form, this convoluted form, and we can get the answers, that we can understand the questions, we can get the answers, we can submit it, and then it's done. And I'm not so sure why it requires individual determinations. It seems to me that this should be algorithmic, that there should be a computer program that says you check the following 17 boxes one way or the other, and you ought to get paid. The key to this whole thing is self-attestation. And if it's under penalty of perjury and you get some emails back and forth and DocuSign, HelloSign, whatever the system you want to use is done, then you've already established or satisfied the Department of Labor that you've done your due diligence. And nobody's going to come back and say, oh, look at Nevada, you gave away all this money and you didn't do it right. If there is fraud and you've gotten the DocuSign and you follow the regulations, fine. If there's Nevada as a state, D.E.T.R is not responsible. It did its best under the circumstances. These same statistics, the same tsunami, can explain why D.E.T.R is not processing quickly, but it also can explain why some fraud may slip through the cracks in order to do the greater good and to follow the law, to pay when due. So I go back to the original renewed application and ask for a a writ that directs D.E.T.R to pay all those people who it has previously said were due, and started by either starting to pay them or having a determination letter that said you're not going to get this program or you're going to get that program, or having a determination letter that says they are eligible. And those three groups would take care of, I don't know what percentage, but a large percentage of the problem. And the other percentage of the problem of people who are in limbo, we have to put some kind of reasonable deadlines on it. And insurance companies love to deny claims and then make you appeal them. And that's what D.E.T.R is acting like. State Farm, or I don't want to slur anyone in particular, but all the insurance companies played this game where they would deny until they were finally sued. And if it wasn't for that, we would not have a bad faith claim against an insurance company. And that's exactly what D.E.T.R is doing. Deny. And then, well, they'll get sued, and then some administrative law judge will tell us we have to pay 3, 4, 5 months down the road when nobody's looking. Nobody cares. Meanwhile, the person has suffered irreparable harm. The credit's gone down. They've lost their housing. They can't have the tools to survive, so they've returned their car to the rental place for Lyft drivers, or they move to their parents' house because they can't have a separate. They can't afford their apartment, or they're on the street, and that's what we're facing. So yes, I'm very impressed with the work that the special master did, and I wish he had done it, 3 months ago. But he hasn't provided the solution to the problem of the 139,000 people who are sitting, 55% of the people who have applications pending for 16, 17, 18 weeks and who haven't been paid. And as I said, and I think it's common sense, very few people have 17 weeks or even 5 weeks worth of savings. And if they're gig workers, unless they're the 1%, it's even less likely. And what you're going to do is you're going to widen this economic gap between this group, which will, by the way, reflect upon its ethnic makeup, which is disaster. And my children will be paying for it for years. So I would say that I renew my motion. I haven't heard anything in this report that contradicts that motion or lessens the importance of that motion or justifies the conduct of not paying people that have already been approved and not setting a reasonable deadline for the people who are in limbo for D.E.T.R to make a decision. Because if I were an employer and I didn't respond within 3 weeks or 2 weeks, that would default against me. That's the way the system works. Well, there is no employer here. That's right. There is no checks and balances. There is no employer. And by the way, some of their questions are crazy because people aren't getting laid off. They're just not having the revenue. They're not having the business because their customers went away. So there is no checks and balances. The system doesn't fit right, but other states have been doing it much better than we have. And even if they weren't, the when due, which is a federal right, is a property right, a due process right, should be at least the earliest possible date, not in September or October. And that's my just visceral reaction. Some facts thrown in, but it doesn't make sense. If you exhaust UI, then you get P.U.A. Okay, so exhaust it. Give them if they have a determination letter saying they're not eligible for UI, and then you blame them for having applied for UI. Well, you were told them to get a determination letter that said they couldn't get UI. They get the determination and they're still not getting paid. Why? Because they're eligible for UI. It doesn't make sense. Pay them. And that doesn't require 30 adjudicators. It requires a checkbook, and D.E.T.R knows who these people are, and computers can tell you exactly who these people are who have been previously approved. And as far as new information going on, if they can't certify their work weeks because they're cut off of the computer, they ought to be given an opportunity to certify their work weeks. If they can't, but other than that, there is no new information. Let's not go back and revisit the past. Leave that for the fraud unit later on to recoup it. It doesn't jeopardize the state of Nevada's position at all. So with that, I think that unless Ms. Jones has something more specific to say, which I'm sure she does with the details.
Well, if I'm going to allow double teaming, it'll apply equally to the state. Ms. Jones, is there something you'd like the court to hear?
I find you in contempt. I am going to incarcerate you.
Pursuant to that Supreme Court rule, your death can be qualified.
This is the time set for your hearing on custody.
Please put in writing your concerns or objections.
Any statement that you make is under penalty of perjury.
No, that's not how that works.
We will take this case under submission.
That would require proof by very significant evidence.
Yes, Your Honor, thank you. Mr. Thierman said something that's really important here. He said, I wish Special Master Ganasio's report had come out 3 months ago. It was an amazing report, but I don't think he could have gone back to the future and wrote the report that you asked for before you asked for it. And that brings us to an important point. Your ruling will be based on whether D.E.T.R acted in an arbitrary and capricious manner or whether it used its proper discretion. Here, obviously, the Special Master has indicated probably half a dozen very good recommendations that will help D.E.T.R do a better job. If it wasn't for Plaintiff bringing this lawsuit, it is unlikely D.E.T.R would ever have taken such a close look at what is going on. We did that in May. Here we are in the middle of June, or I'm sorry, the middle of July, and the problems are still there. One of the frustrating issues about this, and it's probably frustrating for the court, is that each week D.E.T.R changes something. And whatever the court decides, I hope the court, as Special Master Ganasio indicated, will have some oversight in the process moving forward. And I just want to bring up two issues, or actually 3 issues, that are important to look at. The claims process on the computer screens are not that easy. with all due respect to Mr. Guinasso, there are people out there that don't have a desktop computer and are having to navigate this process through their cell phones. If you go onto the D.E.T.R website on your cell phone, it is next to impossible to try and answer those questions. People that are sight impaired or hearing impaired are unable to access the same information and do not have any help from Alorica.
Ms. Jones, let me stop you just for a minute, because while that may be the case, right? Somebody doesn't have a desktop. I mean, where's the level of personal responsibility that we should expect for somebody to make a claim for benefits to support themselves and possibly their family? They don't know anyone that has a desktop. They can't go into an internet cafe. They don't have any opportunity to access it other than on a smartphone. I mean, that's a little hard for the court to swallow. How do you respond?
I understand, Your Honor. And cell phones, wherever, this leads into that fraud argument, actually. Wherever you are on your cell phone, if you're doing it on a cell phone, it will ping to the nearest tower. That may not be in Nevada. If you go to an internet cafe and they have a reputable VPN, that internet cafe's VPN is not going to ping in Nevada. If they had to move in with family and it's outside of Nevada, that ping is not going to be in Nevada. And yes, there is an onus on the claimant to make a claim to prove their eligibility. But one of the things D.E.T.R said in their responses is we're not required to give advice, but we're only required to give guidance. That's semantics. Mr. Guinasso made a recommendation about having an adjudicator that you could talk to in real time and go through those issues, fix them, help those people that don't have English or have English as a second language, help those people who are having problems navigating that system because they're so stressed out because their kids are crying or they're going to lose their house. That's one issue that if we hadn't brought this lawsuit, I don't know if D.E.T.R would have gotten around to addressing those issues. The second thing is granted, D.E.T.R has provided initially for a due process and appeals, but their press release indicates that they will have 30 days from today's date to do their appeal. That was 7/17. So these people will have 30 days until August 17th to initiate an appeal. However, the last paragraph says in their press release, and I quote, "Additionally, functionality for appeal hearing scheduling is forthcoming. D.E.T.R will announce in the coming weeks when the scheduling component is launched in August." So even if they launch it the 1st in August, that's 10 days out of their appeal period. And as Mr. Thierman indicated, now we're looking at perhaps the end of August, maybe September, maybe October before someone actually gets to appeal. That is far too long. So I'm encouraging the court to look at some of the recommendations Mr. Guinasso made to speed that process along. Again, if we hadn't brought up this lawsuit, how long would it have taken D.E.T.R to provide due process through an appeal process? I'm not sure. The second thing, or the third and final thing I wanted to bring up is that each day there seems to be a change on the D.E.T.R website. If you go on the D.E.T.R website right now, you can look, and for a P.U.A applicant, one of the only ways, if you're a gig worker who's had a reduction in work because they didn't actually quit, they just don't have any rides, because a hairdresser didn't actually quit, her customers just dried up because they don't want to get COVID. It says, "I quit my job." That changed as of Friday. So again, going forward, I hope whatever the court determines is that it will keep an eye or help D.E.T.R keep an eye on these processes that seem to keep changing, that cause some of the very problems that are preventing these people from getting paid. That's all I have. Thank you.
Thank you very much. Who would like to respond on behalf of the state of Nevada?
Greg Ott, Your
Please proceed.
Honor. I'll respond.
Sorry,
Yeah,
I
again.
had
Yeah, no, I apologize. I had a feedback issue coming through.
Okay.
But
If
I'll
everybody
start now.
else, yeah, if everybody just mutes their microphone while you're speaking, that would might help. Go right ahead, sir.
So I wanted to start with the fraud issue because there's some numbers being thrown around. It appears that there's still some debate about the legitimacy or the significance of this issue. So I just wanted to point to some numbers that are contained in the Special Master's report. Washington believes it lost $300 million to criminals. That's Special Master's report, page 95, footnote 33. Arizona identified tens of thousands of fraudulent claims. That's page 170, line 6. Colorado saw a rise in fraudulent claims. That's page 171, footnote 65. Hawaii saw $100 million in fraudulent claims. That's page 174, line 8. Montana had to delay payments because of a nationwide fraud scam. That's 175, line 5. Last week, this is not in the report, but Maryland, and it's been in the news, Maryland reported that it uncovered a $500 million unemployment fraud scheme. That's been reported by Forbes and other reputable outlets. Michigan also reported flagging hundreds of thousands of accounts for fraud. It's from the Detroit Free Press. Additionally, DOL confirmed that there are fraud rings targeting these programs. So to the extent that anyone thinks that it's not a real and a significant problem facing the state and every other state, I think the Special Master's report provides significant evidence to contradict that assertion. Next, I wanted to talk to something that Mr. Thierman spent a little time on, which was the stopped payments issue. And this is one of the problems with having a class when you don't have members who are representative of the class. And I know the court hasn't declared this a class, but the stopped payments issue is not something that is specific to either of the two members, named plaintiffs that remain unpaid at this time. People can have payments coming to them, which then stop. Some of the reasons that might happen is they fail to file a weekly claim, which would then mean that they wouldn't get paid for that week because they wouldn't have filed the appropriate paperwork. They could also have earnings in any given week, which would exceed the threshold amount, which would cause them to not receive payments one week when they had payments in the previous week. It's difficult to know what the issue is because we don't have individuals to tie to the allegations that Mr. Thierman is raising. But I just raise those as some legitimate reasons why people could potentially get paid one week and then be ineligible in a week after that. I want to address a couple things that Ms. Jones said quickly. The appeal module that was stood up this weekend was bought when the original system was purchased, the P.U.A. system. As part of building a plane as you are flying it, you build the parts that you need to get off the ground first. You build the things that can get people paid first. Then you don't need the adjudication until you have people who have been denied. So if we had waited to start paying people until we had built out the appeals module, that would have further delayed the payments of people who were clearly eligible. So that was always in process. It was meant to be built last because the quickest way to pay people is to build that module and implement it last. So it had nothing to do, the timing of it had nothing to do with the lawsuit. It was always meant to be built on this schedule. And with regard to D.E.T.R is now paying attention to these claims just merely because this lawsuit has been filed. D.E.T.R looks at these issues every day. They talk to people, they talk to sister states, they try to get answers. That's one of the reasons why things change, is because they're solving problems. When you're building a plane while you're flying it, you are continually troubleshooting and you are continually solving problems to try to get people paid, to get eligibility determined, and to get the process to work better. So the fact, or the allegation that they were somehow spurred into action by this lawsuit is just not reflected by the facts. And I think that's very evident when you look at the Special Master's report. You can see the time and the effort that D.E.T.R has been putting into this from the earliest days of this pandemic. But I want to go back to a couple points of agreement that we have with opposing counsel. And I think the first one is the thoroughness and the really incredible work that the special master was able to do in a short amount of time. Very thorough, put together a ton of work, and formulated into a way that I think is easily digestible for the court and hopefully for the public as well. And the other thing that Mr. Thierman said that we agree with is his lawsuit is not about fixing D.E.T.R. His lawsuit is about paying people. That's what he's asked for. He doesn't want the court to go in and try to fix D.E.T.R. He wants the court to pay people. And so I think that is the crux of what should be addressed. Writs are extraordinary remedies. They're not appropriate absent a clear duty to act. And plaintiffs have shown no clear duty to act here. The original writ requested payment at the earliest of three circumstances. The first was 2 weeks after April 11th. I think the court was not persuaded by that date because that date is not tied to anything. DOL specifically addressed this concern in one of the questions that Special Master Guanasso laid out to him. It's on Special Master's report, page 239, line 3. Question, did DOL establish a deadline for states to implement C.A.R.E.S Act programs or pay benefits? Answer, no. So that April 11th date, not tied to anything. DOL's confirmed that. The other two allegations would be payment upon a prima facie claim, or once a claim is determined financially eligible, are asking D.E.T.R to pay claims before they're determined eligible. And as the court pointed out, Special Master Guanasso asked DOL this question a number of different ways. Those things are specifically prohibited by law, and DOL confirmed that. Page 235 of the Special Master's report, lines 14 through 16. Do states have the flexibility to pay benefits based on minimal showing of eligibility and then deny benefits later if the claimant is determined not to be eligible? Answer, no. See also UPL 2320, Section 4A. DOL is also very clear that D.E.T.R is not in violation of any statute for failure to timely pay P.U.A benefits. There is no statutory deadline for the implementation of the P.U.A program. That's page 243, line 2. The basic premise of the writ was that D.E.T.R was misinterpreting DOL guidance. It's a very rare case where we get the opportunity to ask for interpretation of the guidance in the middle of the case, but those are the facts that we have here. Fortunately, DOL was able to respond to the Special Master's questions and to clarify that what Mr. Thierman has asked for in his petition is not only not required by law, in most cases, it's specifically prohibited by law. So it's not even something that D.E.T.R could do if it had the discretion. And keeping in mind the standard for a writ is not for the court to order the executive branch agency to exercise discretion. It's to order when there is a clear duty that the executive branch agency is not asking. So I think that the DOL guidance was very clear. I think that it was clear before that they were not entitled to the writ, but I think it's even more clear now after DOL has weighed in that the appropriate thing for this court to do is the same thing that the Florida court did when it was confronted with a request for a writ of mandamus to pay claims before eligibility was determined. That's in the Special Master's report. And so simply following the plain language of the law requires the denial of this writ, just like they did in Florida. And I would point out that DOL also confirmed the sword of Damocles that is hanging over these programs is real. The federal programs operated by states through an agreement with the Secretary of Labor, such as the C.A.R.E.S program, can be terminated if they're not performed in coordination with the agreement. That's Special Master's Report 235, line 25. So the law requires the writ to be denied, but I think also public policy mandates the writ be denied, because even if you were to issue an order that were to require payment in violation of DOL requirements to get some minority of claimants paid, you would be jeopardizing the claims of all of the other people who are already getting paid and getting paid good money, because DOL could come in and terminate the agreement at a later date. Again, I don't think you need to get there, because I don't think you need to have the policy argument. I think the law is clear. There's no specific requirement for D.E.T.R to do as plaintiffs ask. And so we ask that the writ be denied.
Mr. Rod, thank you. Would you like the court to hear from any of your colleagues?
Unless Robert has anything to add, we're good up here.
Okay.
Thank you, Mr. Ott. Your Honor, just really quickly, Mr. Ott, I think, did an excellent job of summarizing the arguments, and I don't really have much to add other than to, again, bring to the court's attention that there is an obligation upon D.E.T.R. Reading through the UPLs. This was again brought up at the last hearing, if my memory is correct, which is an if sometimes, that as well as promptness, when looking at the term when due, DOL also looks at accuracy to ensure that those payments are not to be made when they're not due. So to basically make sure those payments are made to people that are legitimate claimants and legitimately entitled to those payments. And as Mr. Ott pointed out, on page 239 of 310, DOL in its response to the questions did indicate there's no time limit for the establishment of the P.U.A program or P.U.A payments. Now, again, it's not like D.E.T.R's just sitting back doing nothing. But again, as Mr. Ott pointed out, we're looking at a writ here, and those standards apply. Anyway, thank you, Your Honor. That's all I wanted to say. Thanks.
Mr. Thierman, seems pretty cut and dry from the state's perspective. Why should the court find otherwise?
Because the state never addressed the people who were told that they were eligible. I mean, what they were talking about was the original writ. I modified it, and then I filed a second re-noticing of this motion, and I asked for the people who were notified, either through a letter determining that they had been approved, eligibility approved, not monetary determination, not the amount, but the actual eligibility, or they received benefits, stream of benefits,
The chance to respond.
or they were told that they have UI as opposed to P.U.A, and therefore they're approved as to UI. Those three groups of people were approved, and they don't answer that question. And that's your due process. That's your straight Java. That's in the Secretary's, both his Secretary of Labor's response to them and into that earlier memo that I just introduced. You cannot redetermine retroactively. That is what due process is. It's the establishment of a right. In this case, it's the right to benefits by federal statute that has been determined that they are entitled to, and therefore the property right goes over to the claimant, and it's up to the state to take the ball away, using, I don't know, some sport analogy, and they have to do that through the proper hoops. So I will concede that there is no deadline in the act for doing it, except as the Supreme Court says, as soon as possible, as soon as administratively possible. I don't know if you looked at the Illinois case, like Jenkins, where the DOL said, where the state of Illinois EDD, or whatever they call their state agency, said that the fact that someone has been arrested for a crime in connection with the employment and incarcerated is a reason for us to hold in abeyance their payments under the UI. And the Seventh Circuit said, no, it's not. You can't make those generalizations. It's not reasonable cause to believe. It's, if you want to make a determination individually that they in fact engaged in that behavior that would disqualify them, do it. But you cannot turn around once they're getting benefits and take those benefits away. And you cannot presume or refuse to process their their UI application simply because they happen to be incarcerated or out on bail, even though you know and I know and everybody in the court recognized that you're probably never going to get the money back anyway if you do pay it to them, because 1/3 of that group was not convicted in court. Here we have 50% or 55% of the claimed fraudsters on page 117 only adds up to less than half of the amount of people who aren't getting paid. And of those, again, we have generic, broad-based allegations of fraud. And if there's a specific fraudulent allegation on a person who hasn't had his application processed yet, fine, flag it for fraud and let's litigate the fraud. Because right now these people are appealing things, they don't even know what they're appealing. They're being kept in the dark. They're not being told that their claim is denied because of fraud. They're not being told their claim is, they're not being told anything. It's in process. There are issues, but we won't tell you what they are. That's not due process either. So make a decision and then move on. The people who you've already made a decision for, that is those you've approved, those 3 groups, continue paying them until some judge says that you shouldn't after a hearing. Now, eligibility by week, sure, but don't lock them out of the, and that's not a fact that you can decide at the time you make the initial determination. And that's what
All right, hold the thought for a minute. Mr. Ott, let me ask you this. What do we do about the, and I forget the word the special master used, conundrum, purgatory, whirlpool of those who have applied for P.U.A. benefits but have been told they need to exhaust the UI program first because apparently they have a balance. But then they have arguably a letter that suggests they're not eligible for UI benefits. What do we do with those people? Because that is of particular concern to the court. How does the department plan to address that? Assuming that's happening. Maybe you say it's not happening that way, Judge. Factually, that's inaccurate, but go ahead.
Well,
Mr.
I do want to add the caveat that we don't have any of those people before us as named plaintiffs. So
we understand that within the 6 hours of this hearing ending, Mr. Thierman could likely amend the complaint and add such people. And again, the court is not used to and not inclined to rule in hypotheticals, but because we know the realities here, I'm curious what the state's response would be.
Your Honor, I could answer, but I think Administrator Gaw is capable of giving a more fulsome answer if the court would allow it.
Sure. Absolutely. Good morning, Administrator Gaw, and please recall you are still under oath. Please answer that if you would.
Yes, Your Honor. With regards to your question, if somebody is denied benefits in UI, they would have to reapply under P.U.A. if they meet the criteria under the P.U.A. Eligibility requirements. So
well, we all know that, but the reality appears to be that people are either being locked out of applying or reapplying, or they're not getting the benefits under UI, or there's a disconnect there. I don't want to repeat everything that's in the special master's report or what Mr. Thierman's argued. He's been relayed, but would you agree that there are people that are in a little bit of limbo?
I guess if that's the term you want to use, we know that.
What term would you use?
Well, I believe many of them are in adjudication process in UI right now. So if they were denied benefits because they were determined they have UI monetary eligibility, they're required to go file for a UI claim. They would have to be determined ineligible for UI before they could come back and reapply for P.U.A. That is the design of the act, and that is the guidance that we've been given by the Department of Labor that we must follow.
Okay, and if the system worked as well as you're suggesting it ought to, we wouldn't be talking about this as an issue. Apparently, though, some people are having an experience that they are either being advised there are benefits available in UI, and then there's a delay in applying and receiving those, or they're being told there is no balance, and you can go to P.U.A. application and being told, no, you still have to go back to the UI. There's something that's just not working, or else the court wouldn't be looking at thousands of people that apparently are caught in this, I don't know, gray area, no man's land conundrum. Factually, does the court misunderstand what's happening, or?
Conceptually, I would not say that's a misunderstanding. However, I don't have an example of an individual who has been filing in P.U.A., then sent back to UI, been denied UI, and then tried to reapply in P.U.A. We do know that as a requirement per DOL guidance, that once change of quarter occurred at the beginning of July, that we are required to recheck for UI eligibility because people may have had other wages that became available for them to file for UI. So I suspect that a large number of the people that we're seeing now are people who have new UI eligibility that didn't previously have it. And so now are required to go back and file for standard UI.
Wait, so what if somebody's already receiving P.U.A. benefits and based on the quarterly update, I'll use that phrase, they now have money coming to them under UI? Do their P.U.A. payments get stopped and they get redirected back to UI to zero out that balance first?
Yes, according to the guidance that we've received from the Department of Labor, it must stop in P.U.A. because the new eligibility has been detected, and they must go reapply for those benefits that they're eligible potentially for under standard UI.
All right. Well, I can see that if that's happening, would be causing a great deal of confusion and concern. Let me ask the special master. What do you recall the evidence showing with respect to people sort of caught in this middle ground here between the UI and the P.U.A. worlds?
Yes, thank you, Your Honor. That was a major complaint. It's if you look at the Appendix 1, we outline that group of people that exist. So we know that they exist, and there's specific examples. I don't know if those examples are how widespread they are throughout the rest of the system, but we had hundreds, if not over 1,000 people that fit into that space. And they're really stuck in this place where there's no, again, it's like a loop or a purgatory where they're not getting resolution to their issue. And when the term adjudication gets used, I think it's important to put in perspective, there are only 35 adjudicators for this massive amount of issues. And so how do you work through that many issues with such few people, on the front lines dealing with?
Well, the 35 is itself a significant increase, as I recall from the last hearing, of the number of people that were in that role before recent events. So I'm assuming the department is doing it the best it can to qualify people, repurpose people, and try to assign them to areas that they can handle, which will help unplug the backlog a little bit. Administrator Guy, is that happening? Are the administrators, are the numbers increasing, and are they being allocated to the areas of most concern?
Yes, Your Honor. We have been actively recruiting for a number of months, and we have had substantial barriers actually to bringing on additional adjudicators, just because we've exhausted multiple hiring list attempts. We have even gotten creative in seeking a different type of classification than our standard adjudicator to have the ability to widen that class of group of people that could meet the similar kind of work and meet the requirements needed to adjudicate claims. And we've been actively hiring them, and I think we've probably had people start as recent as last week. So we are doing everything we can to find individuals, to augment staff, We also have a number, limited number that we can bring on. I have to go through a number of processes to bring on state staff. I just can't say I want to hire 100 people. But it has been fast-tracked during the pandemic. Hiring the 100 and some odd people that we've already hired during the pandemic is usually something that takes a matter of several months or more in a standard situation and setting. Additionally, we're looking at additional contracts for augmentation for staffing, but that's not public yet, so I can't really speak to the details of that, but we are looking at that as well.
Your Honor.
Go ahead.
I mean, maybe it's just me looking at it as an outsider, but there seems to be some sort of schizophrenia. D.E.T.R is D.E.T.R. They administer all those programs. So for D.E.T.R to say you need to apply to D.E.T.R makes no sense to the common person. And if D.E.T.R tells them to apply, then they say, well, you have duplicate applications on file. And I don't think it's an adjudicatory problem. I think it's a workflow problem. It may be a computer problem. It may be I don't know what it is. But when you have a UI claim that they say on their letterhead, you are not eligible for P.U.A. because you are eligible for UI, bing, you've triggered FPUC. And to me, you've triggered eligibility for UI, you ought to get paid UI. Why is this? Oh, well, they're supposed to know to reapply, and we'll wait another 6 weeks for an application to be reviewed. You already said they're eligible. You said they're eligible. That's why you didn't give them P.U.A. It is, it's catch-22. You can't
Mr.
win.
Ott, would you like to respond to that?
It's hard to respond when I don't have letters that he's trying to quote from. I don't know if the letter says what he says it is, or if he's mischaracterized it in some way. So the systems are set up so that you cannot take an application from P.U.A. to go to traditional unemployment. That is the way that they work. And so I guess if Mr. Thierman had it his way, we would have to assign staff to then fill out UI applications for every denied P.U.A. application, which would further slow down the process. We're trying to make the process run quickly, which is why we rely on those people. Once you get denied for one, you can go apply to the other. The systems don't communicate. So.
But then why did you deny them on the basis
Hold
they're
on.
eligible?
We're not going to do it that way, Mr. Thierman. Okay. I'll give everyone 2 minutes to just summarize any last thoughts. Then the court's going to make a decision. I really would like to turn to Ms. Jones, but I guess I'll hear from Mr. Thierman one more time. Mr. Thierman.
No, Ms. Jones.
Ms. Jones, go ahead.
Both D.E.T.R and petitioners have quoted this language, and I'll just close with that for your honor. It's on page 207. It says, based on UIPL 0401, as well as promptness, the department has always interpreted when due in section 303A1 of the Social Security Administrative Act to require accuracy in order to ensure that payments are not made when they're not due. We all agree with that. C 20 CFR 602.11A and 602.21 subsection C. Proper application of section 303A1 requires an appropriate balancing of the dual concerns of promptness and accuracy in the when due provision. I think that that's key here, and that the recommendations that Special Master Guinasso's made can go very far in helping the court do that. And also, as Mr. Thierman said, the people that have been given eligibility letters, not just estimates of payments due, should be paid sooner as opposed to later, not 30 or 60 days when the appeal process gets moving. Thank you.
Thank you very much. Mr. Ott, final thoughts.
Certainly, Your Honor. I think one of the things that the Special Master's report made very clear is that Nevada was hit with a tsunami. The charts on pages 20 and 21 tell that story more succinctly than any of our words could. I think it's unlikely that you'd find anyone in the state who hasn't been impacted in one way or another.
But let me stop you, because the question is not whether we've been hit by a tsunami. We have. The question is, what do we do in response? And the plaintiff says, Judge, their response is not the proper exercise of their discretion. They're either misreading or misinterpreting the law and guidance, or they're making decisions that are manifestly abusing their discretion. So we've all been hit by a tsunami. No one on this call, no one watching, no one listening, no one who's lived here, worked here, educated here, retired here would think any differently. The question is whether D.E.T.R's actions have violated the law with respect to how it has handled responding to the tsunami. So, Mr. Ott, you say the state's response has indeed been proper, taken into account the extraordinarily difficult challenges it's faced. Do I have that right?
Yes, absolutely, Your Honor. That was more succinct than I could have been.
Is there any of these issues, these 5, 6, 7 subsets of people or claimants or issues that have been raised by the petitioner that you as counsel for D.E.T.R, when you saw that, you scratched your head and said, you know, maybe there's something there. We should have been approaching this differently than the way we have. Is there anything like that that you can share with the court, or do you feel like D.E.T.R's following the law best it can under extraordinarily difficult circumstances?
It's the second. I feel like D.E.T.R is following the law and the guidance as best it can under extraordinary circumstances. And I don't want that to give the impression that D.E.T.R is not constantly looking for process improvements. Whenever you get a report that's this thorough, you look through it and you see if there's things that in there that could help. And those discussions have gone on and will continue to go on. But the succinct answer to your question is yes, I think D.E.T.R has followed the law the best it could under extraordinary circumstances.
All right. With that, the argument portion of the hearing will be closed. The court will be in recess for 15 minutes. At approximately 11:45, I'll come back and put the court's decision on the record. We'll be in recess. The court is duly impressed with the mutual professional respect that each side has shown in this case to this point. It's rare, but certainly encouraged by the court for this type of collaborative working together. That doesn't mean you don't each vigorously fight for the views and the position that you advocate for. It means that you are respectful of the court staff, each other, the process, the court's special master. And so the court recognizes and thanks each side for their manner in which you've conducted yourself. That's number one. Number two, findings. Mr. Thierman and Ms. Jones pay particularly close attention because I'm charging you with drafting an order consistent with the court's findings for review and collaboration with the state. Stating the obvious, the COVID-19 pandemic has caused unprecedented economic harm in Nevada. Its scope, its depth, its swiftness has never been seen before in this state or any other. And hopefully the likes of which will never be experienced again. Its effect on Nevada has been especially devastating, created by really a perfect storm consisting of many things, including but not limited to, number one, already decreased D.E.T.R and Employment Security Division staffing levels resulting from funding, federal funding calculations made during Nevada's robust economic times. That's nobody's fault. That's just the reality. Number two, a bit of and these are the court's words, nobody actually said it, but the sense the court gets is a somewhat outdated or antiquated, hardware or software system being utilized to run the usual unemployment insurance program, website and attendant, computer and technological needs. Third, the need, therefore, to create from scratch a pandemic assistance benefit administration program rather than, again, this is not a technical term, it's a lay term, but stack the new program upon or within the existing UI program. The decision to do that appears to been made by senior administration at D.E.T.R or ESD. And as the court will jump ahead to conclusions of law, there's no abuse of discretion that the court would surmise from that decision. Number four, the nature of Nevada's primary economic driver, gaming and tourism, and the resulting almost total shutdown of huge sectors of the economy based on justifiable concerns for public health and safety. Finding of fact number 5, court takes judicial notice of the fact that there is an especially large English as a second language workforce with attendant difficulties navigating either or both of the UI/P.U.A. websites. Those websites appear to be user-friendly to an extent, but can be a bit confusing, particularly to someone who's not familiar with all the language and all the requests being made of them. 6, the call center performance has experienced serious challenges. And while there's enough blame to, be distributed about, the reality is the challenges were no doubt aggravated by the urgency of establishment, which resulted in significantly shortened agent training periods. Does that, as an aside, does that relieve a representative of showing compassion and respect to those that call? Of course it does not, but it can as well account for some of the gaps in knowledge and ability to directly assist, as we would expect a group like that to be able to do had it had additional time to prepare. 8, the nature of the work histories of many of the so-called gig workers, hundreds of whom may reside outside yet work inside Nevada, or who worked intermittently, or who tried to work somewhat and did not completely stop working during the pandemic. 9th reason why this factual scenario created the perfect storm in Nevada is the likely presence of some imposter or social media robotic influencers designed not to share genuine experiences for collaborative benefit, but rather to unduly pressure, harass, or attempt to intimidate state employees and or policymakers to act in a way consistent with their view. 10, the time it takes to train new hires or repurpose hires from within ESD to be in a position to provide clear, competent, knowledgeable assistance to those seeking information or clarification of their benefit claim status. And confirming next what the special master suggested, the sheer number and volume of applicants for benefits indeed caused a tsunami of those seeking help for which no state, particularly a state with all these other factors I've just indicated, could have been properly prepared. I might add as well, it was not discussed today, although it's in the briefing. Another reason this is a particularly challenging time for Nevada is the C.A.R.E.S Act administrative funding component apparently requires prepay by the state actor who then seeks reimbursement. And while that's certainly appreciated by those who can use that bucket of funds for administrative purposes, well, it does require upwards of millions of dollars to be outlaid by the state, apparently, in order to be in a position to request recoupment. And if you're already running thin with budgetary constraints and staring down extremely large shortfalls, I'm sure it caused a lot of concern and difficulty in the state being in a position to pre-fund the C.A.R.E.S Act administration component. Those are challenges that made the effect on Nevada especially daunting. There are other findings, though, the court wants to put on the record. The court finds that the C.A.R.E.S Act and the unemployment benefit component is designed to be remedial. It's to remedy the pain and economic harm that people in each state are experiencing that are legitimately pandemic related. That's one of the reasons, as the court understands, that the application for benefits is allowed by self-attestation. Somebody need, among other criteria, swear under penalty of perjury that the information that they are supplying is accurate and honest, as opposed to, the dual opportunity to verify. Of course, there's no employer to be at the table to protest any inaccuracies, but so the reality, particularly for part-time, piecemeal, or gig workers, is that self-attestation is how it has to be. But nevertheless, the mere fact that this law allows people to apply for benefits on their own word is itself evidence that it was designed in a way to assist people as quickly and thoroughly as possible in their time of need. The C.A.R.E.S Act apparently, with respect to unemployment insurance benefits, has eliminated the requirement of searching for work during the benefit period. That's, again, a product of two things: the reality of the difficulties and potential health and safety concerns of searching for work at this time, and also the need to distribute benefits as promptly as possible. And then finally, believe the usual unemployment insurance program requires either a 1 or 2 week waiting period. But in any event, I believe the P.U.A. program has done away with the waiting period, all suggesting to the court that thoroughness, but yet swiftness, is the goal. The court finds, as a finding of fact, that this particular act is particularly vulnerable to fraud. Other states have experienced it in greater number and amount than Nevada. And the threat of fraudulent applicants is real. Guidance, legislative history, and answers from the Department of Labor to questions posed by the special administrator all emphasized the seriousness with which the United States government takes the state's responsibilities to take due care to limit and circumvent fraudulent applicants and safeguard the people's money to ensure it goes to the right place. The court finds that the efforts of Administrator Ga and her senior staff have showed extraordinary vision and leadership in extremely difficult times, as well as former Administrator Korlick, who I'm aware no longer works for the department any longer, but who worked, no doubt, extremely hard under difficult circumstances to stare down this tsunami. Those lead us up to the final finding of fact, which is that benefits have been delayed. Delayed more than they should have been for many people. And we'll talk what we're going to do about that in just a moment. Conclusions of law. And Mr. Thierman and Ms. Jones, there's a very good chance that this court's decision will not be the final stop in judicial review of this dispute. So I'm reminding the petitioners here, the plaintiffs, that if there are issues with regard to standing or mootness or jurisdiction, these are arguments that you've advanced and convinced the court at this stage tilt in your favor. But the court notes that it's an extremely close call, but nevertheless, the court concludes, issue of law number one, that the court has jurisdiction to hear this matter and that the claims are not moot. The court will note Mr. Thierman's argument that some claims are capable of repetition, but yet can evade review. Because by the time review comes, the issue's been resolved somehow, but yet they can resurface again with other people, other entities at other times, and that fact can make what otherwise might be an unripe case ripe for decision. The court finds that these claims fall into that bucket. So the court believes, as conclusion of law, that it has the ability to move forward with this case and does so. Borrowing from the briefing, Nevada Revised Statute 34.160 empowers a district court to issue a writ of mandate directing, in this case, another branch of government to perform an act which the law especially enjoins as a duty resulting from an office. Now, in the usual phrase, enjoin means stop, but in the way it's used under NRS 34.160, it means to move forward. So the statute gives a district judge the authority in certain cases to issue a writ, issue an order directing a state, or in this case, a department of the state, to move forward. When should a court exercise its discretion to do so? Well, the law is clear. Writs of mandate are properly issued when there is a clear present duty to act. The court is citing from the Newman case decided by the Nevada Supreme Court in 1981, found at 97 Nevada Reporter 601. That's still good law. That's still the law of the state of Nevada. Furthermore, courts may issue writs of mandate where there is not a plain, speedy, and adequate remedy in the ordinary course of law. Court finds that applies here. There is no other approach petitioners could take to obtain the relief that they seek, at least under the time periods involved here. Court notes that writs of mandate are extraordinary remedies. Writs of mandate are normally only appropriate where the relevant facts are not in dispute and a clear question of law is presented. Now, certainly, importantly to our discussion, writs of mandate should not be issued in order to control government's discretionary acts unless the discretion is abused or exercised in an arbitrary and capricious manner. Petitioner, in this case the plaintiffs, as I mentioned at our last hearing, have the burden of demonstrating that that the issuance of a writ of mandate is warranted. If they don't meet that burden, or if it's 50-50, the writ does not issue. Well, what does arbitrary and capricious mean? In our context, really a pretty good definition of that is an agency, in this case D.E.T.R's actions or decisions while based on consideration of relevant factors, suggest there has been a clear error in judgment. District courts may reverse or change an agency's determination if an agency relies on impermissible factors, fail to consider an important aspect of the problem, offers explanations for its decision that run counter to the evidence, or is otherwise so implausible that it could not be ascribed to a difference in view or the agency's expertise. Well, where does that leave us? Does the court find that that D.E.T.R's actions have been arbitrary and capricious, or that it has abused its discretion in the manner in which it's administered its legislatively required responsibilities? The answer to that question is somewhat. In fact, to a large degree, the court thinks it has done just fine. It has exercised its discretion properly, made decisions rationally based on the evidence before it, used its expertise to come up with the best solution. I'll give you an example. Standing up the appeals process protocol after the claims system was established and claims are being reviewed and paid or not, adjudicated, that makes complete sense to the court. That's an example of the exercise of discretion that was wholly appropriate and proper. But in 3 ways, the court finds an error in the manner in which D.E.T.R has approached this. The first way is somewhat modest, but nevertheless important. And I apologize to all involved that it's taking the court so long to identify its decision and the basis therefore, but as we all know, this is a fairly involved case with a lot of moving and fluid parts. So I apologize for the delay. Guidance from the Department of Labor, and I'm referring to pages 80 and 81 of the Special Master's report, provides examples of what may constitute a qualifying COVID-19 related circumstance for P.U.A. eligibility. So we're way down here. Because obviously to get benefits, you need to have a qualifying COVID-19 related circumstance. But these are examples. One of the examples on page 81 is an individual works as an independent contractor with reportable income and is either unemployed, partially employed, or unable or unavailable to work because the COVID-19 public health emergency has severely limited his or her ability to continue performing work activities and has therefore forced the individual to suspend such activities. For example, a driver for a ride-sharing service may qualify for P.U.A. benefits if he or she has been forced to suspend operations as a direct result of the COVID-19 public health emergency, such as if an emergency state or municipal order restricting movement makes continued operations unsustainable. The court understands that D.E.T.R has been construing someone who drives for a rideshare program ineligible if they don't completely suspend their activities. The court believes that's an error. The court will construe suspend to mean or have the functional equivalent of substantially interfere. To do otherwise, in the court's estimation, would lead to an unfair and unreasonable result. By way of an example, a Lyft driver who works in Clark County and the hotels and casinos have been shuttered, at least they were, or whose operations have been significantly scaled back as they are now. Well, if they completely suspend operations because of COVID-19 and orders of the executive branch, they might otherwise qualify. But if they work a few shifts, a few hours a day, 10, 15, 20 hours a week, well, according to the D.E.T.R's interpretation of this guidance, they would not qualify. I think that's error in judgment, because that would penalize somebody for trying to support themselves or their family. Or, for example, take a senior to a doctor appointment who doesn't have another ride. Take anyone to go see a relative or loved one. Go shopping. Take someone to go food shopping. I mean, we are not going to penalize people under the C.A.R.E.S Act because they try to maintain some level of subsistence income while they wait for the economy hopefully to right itself or otherwise have benefits available. So to the extent that benefits have been delayed or outright refused because of the determination by D.E.T.R that suspend means completely suspend, the court finds that error and an abuse of its discretion such that a writ will issue ordering payments to be made to people that otherwise would qualify and fall in that category. Again, this is part art and part science, but the court provides its definition. Suspend is the functional equivalent of substantially interfere. I think that's consistent with the goal of the C.A.R.E.S Act. That's number one. Number two, the court believes that the United States Supreme Court case, California Department of Human Resources versus Java, 402 U.S. 121, which came out in 1971, and guidance from the Department of Labor, for which expands its view of what that case means relative to unemployment benefits. The court believes that to the extent D.E.T.R has started benefit payments to an applicant, then stop them for reasons other than the applicant did not weekly file, the applicant has earnings in excess of the allowed, not allowed, but in excess of that which would otherwise qualify the applicant for benefits, or the D.E.T.R has clear and convincing evidence of fraud, then payments may not be stopped. The court believes that a fair reading of Java suggests that to do so would be misconstruing the law by D.E.T.R, and that ends today. D.E.T.R is not to withhold benefits that have already started, absent one of these three reasons, or otherwise after a hearing and an opportunity for the beneficiary to state their case and respond to the reason that the state would like to stop their benefits. Lastly, and I'm going to need a little bit of clarity here because I thought I understood it, but now I'm starting to rethink this. The FPUC payments, as the court understands it, are otherwise available to someone who is receiving the UI or is receiving the P.U.A. benefits. And therefore, if somebody qualifies for one or the other, those payments should be layered on top. Mr. Ott, is that what the law provides as the state understands it? You're still on mute.
Sorry, that's correct, Your Honor. If they're eligible for either program, they get paid FPUC.
All right, so again, so this is the third part of the writ order that's being, the writ of mandate. The court orders that the FPUC payments be made to parties that the state believes would otherwise qualify for one or the other of the two programs. Now, what does that really mean here? That means that they have, of course, this goes back to when somebody qualifies for the benefits in one or the other program. But actually, I'm gonna walk back that part of the writ. That all goes to eligibility and who receives a favorable determination, and how can the court order FPUC payments when we don't know where they are. So the writ will issue on the two issues that I've just stated. The Java-inspired portion of the writ and the court's reading, reasonable reading of the Department of Labor guidance on people who are trying to earn something. They should not be penalized because the court doesn't believe suspension should be interpreted that way. Now, the order will deny without right to renew the other issues sought by petitioners. We're going to have, and we're going to go through in greater detail some of this shortly, but we're going to have a hearing unless somebody is absolutely unavailable. Thursday, July 30 at 10 a.m. And the court wants to see some level of response between now and then from the state to issues like the P.U.A. backlog. It's unacceptable to the court, but not quite. The court is not quite moved to find an abject abuse of discretion or arbitrary and capricious conduct by the state. But we're edging that way. That people are in this no man's land where they're being blocked from benefits in either one. So I'm hoping that the state can come forward in 10 days and educate the court on steps it's made to unblock that group of people. That's number one. Number two, what steps D.E.T.R has made to move the first filers to the front of the line, or to the extent you already are doing that, what progress has been made. Number three, the issue of people who have sought benefits apparently from February 29 of this year, leap day, through March 5th. Apparently there were a group of people that the evidence reflected were not eligible for payments because the first confirmed case of COVID-19 in Nevada didn't occur until later. But the court is persuaded that D.E.T.R, if you're not already doing so, needs to look and see the reason why those people's income appears to have been affected, particularly if they were working with people or traveling to or dealing with businesses that had been affected already. So the mere fact of Nevada's first confirmed date is of no moment. It's relevant, but it doesn't end the story. I would like, when we meet on the 30th, to hear from the state positive developments on the P.U.A. dichotomy, which the FPUC payments on top of that will hopefully flow as well. I would like to hear what is being done for the first filers, and I would like to hear what is being done for those who have applied for benefits for the first week of March, as I've just stated. To the extent the relief sought by petitioners exceeded what the court has just said, the court is not convinced a writ should issue. The court would like to keep the special master on at least until the 30th to be available as a resource or facilitate educating the court on what's being done over these next 10 days on these three groupings. Now, I'm not suggesting, Mr. Guanasso, that it become a 60-hour-a-week project like it was or more. I'm expecting a much marked decrease in your time, but I'd like you to be available as a resource, occasionally interface with both sides, and so that you can be on the hearing on the 30th and answer any questions that the court may have. With respect to when payments need to begin on those issues that the court has granted the writ, the answer is within 5 calendar days of the order being filed in this matter, consistent with the court's oral decision. I would like to have a draft of that order by tomorrow afternoon, which means Mr. Thierman and Ms. Jones, you have to create it, submit it to the State Council for review and comment, try to work with them so that it accurately reflects the court's decision, at least on the form of the order. Obviously, the state does not agree with the state with the court on the substance, because they suggested no writ should issue at this time. But in terms of the form of the order, I'd like for you to reach consensus. If you cannot, then Ms. Jones and Mr. Thierman, you submit but do not file by email to the court your proposed order. The state is to submit but not file yet its objections to or competing proposed order. The court intends to look at it tomorrow afternoon and Wednesday morning, and file the order by close of business on Wednesday, the 22nd. Payments will then be due pursuant to the order embedded in the writ within 5 business days, which would then be Tuesday of next week. If there's going to be appellate review sought of this court's order, that gives the movement time, either side, if they feel aggrieved. The next hearing, make no mistake about this, it's not an order to show cause a hearing. It's not a why should the state be held in contempt for failing to abide the court's order hearing. It's I want to see progress on the issues I've identified, and I'm expecting there to be no issues with what the court has ordered, which will be filed on Wednesday of this week. Of course, we can use that time on the 30th. If there are questions, if there is feedback, if there is confusion, the court will address it at this time, and if necessary, amend the order. But doing nothing in response to the order, that would be a problem. I'm not anticipating anybody would knowingly violate the court's order. Let me start with plaintiff counsel. Do you have any questions with what the court has just identified?
This is Mark Thierman. So am I to understand, though, it's a final appealable order as to the issue that you're putting on for hearing anyway, or is it not? In other words, you said you're edging towards a writ maybe in the future if there's no fixing of the UI P.U.A. conundrum. Is that a final appealable order now, or do I wait until we hear how close to the edge we get?
That's a decision. That's a decision for you to make. And I didn't use the word fixing. I said I want to see progress. In another subset of my job description here, I deal with criminal justice matters, and I often speak to people and say, I'm not looking for perfection, I'm looking for progress. I would say here that that's probably what the court's looking for between now and the hearing on the 30th. So I'm holding in abeyance the court's decision on the writ, unless you want the court right now to affirmatively say, Mr. Thierman, it's denied, in which case, if that strategically is what the petitioners are asking for, and I won't put you on the spot, you don't have to make that decision right now. You can advise the court by virtue of the proposed order that you want to submit. If you want the court to outright deny it, I'm assuming the state will not object to that, and then you can decide what to do. But you don't have to decide right now. Any other questions, Mr. Thierman?
No, and no, thank you, Your Honor. I didn't. I could answer right now. I don't want to deny it because I'm not sure what my appeal rights are without a total dismissal anyway. So.
Okay. All right, Mr. Ott or Mr. Whitney, any questions about what the court is ordering at this point? I can't hear anyone talking, so if you have a position, please state.
Sorry. A couple questions, Your Honor.
Go ahead.
For the purpose of appealable issues, have you made a determination regarding class?
Well, I'm not certain. No one has asked the court to certify a class, and nor is the court doing it sua sponte. I am finding that that this case is not moot merely because most of the named plaintiffs have had their claims. I'm not sure if adjudicated is the right word. They've begun receiving benefits, but many of the issues here can affect them. And to some people who are not currently plaintiffs, the issue can be repeated, but evade appellate review. So that's the way I'm going to answer your question. The court believes it has the authority to order as it did, and has done so. But go ahead. What else?
Second question, Your Honor. At the last hearing last week, we had a special master and appointed, and we were responding to one writ, and then there was an amended writ, and then there was another filing. You've set out an agenda for the next hearing on July 30. I want to know if that agenda is subject to further amendment. Should the writ be further amended, or should further pleadings be filed, or should we be focusing on these three issues, notwithstanding whatever else gets filed?
Here's the answer. I want the state to focus on the three issues the court has just identified. If there is something the petitioners file, the state has the opportunity to respond, but it's not right now set for a hearing. The hearing will be on the status of progress, if any, the state has made on the three issues the court's identified that the court has concern about, and to the extent the special master can hopefully verify factually the progress that's been made, and then to respond to any questions with respect to how the court's order expressed on the record now and memorialized Wednesday is being followed. That's what the court envisions. Now, if the state wants to respond to some or all of the recent filings by the petitioner, you're certainly welcome to do so, but I don't yet have that set for hearing. Mr. Guanasso, do you have any questions of the court at this time?
No, Your Honor, thank you.
All right, with that, we're going to have to end this. The court has to jump on something else. Appreciate everyone's professionalism. I look forward to seeing you on the 30th, Mr. Thierman, and please submit an order, hopefully a collaborative, agreed upon form of order, if not your proposed and the state's proposed, or just objections to the petitioners, and the court anticipates following the order by Wednesday and requiring payments to begin consistent with that order no later than Tuesday of the following week. With that, the court will be in.
Your Honor, in the beginning of the hearing, you said you were going to, or you were advising the clerk or the reporter to basically give you rough notes, and I presume, and you actually did say to the parties too.
Yeah, so Ms. In, please, when ready, please get a rough draft of the transcript to the court. I'll look it over and, assuming no issues, likely direct you to get it to the parties as well. But please also prepare a final of the transcript at your earliest convenience. All right, with that, the court will be in recess. Thank you, everybody.
Thank you, Your Honor.
Thank you.
You're welcome.